what is going on, and we should all be concerned. For close to a month is being exhumed and survivors being rescued. As rightly submitted by Mr. Abubak Malindi, reports indicate that when exhumations resumed on 9th May, any of the respondents bond with the investigations and witnesses. The state submitted that the offenses under investigation, that he enjoys a huge following, and if released, chances are high that the respondents will interfere with the investigations and witnesses. The first respondent did not Oscar Kipchumba versus Republic. Joel Ngugi J, as he then was, observed that it is not enough to proclaim in order to restrict the person's right to be released on pre-charge bail. This interference. Witnesses would be a good pointer to direct interference of the witnesses. In considering the stated fear is real and demonstrated and not merely speculative. It is not automatic that where the suspect is related to the prosecution witnesses, interference is aimed at interfering with the witnesses or is in a position of power and influence regarding this particular ground, I quote. However, this factor does not dictate the bond or bail conditions to ensure that the relationship between the accused person and the state alleged that the first respondent was released on bail by a Malindi court in misleading. I'll take that again. The state alleged that after November 24, 2023, it was established from a reliable witness account that forest to Kakuyuni Forest. It was also alleged by the state and counsel for the victim mental and psychosocial treatment and support in various to be afraid of him. The state further alleged that the rescued victims will remain vulnerable. It is the position of the state that most of the victims are yet to record. There is a reasonable apprehension that the victims will have genuine fear or have their Some of the respondents may have recruited their spouses and children into the religious outfit. It is believed that some of the deceased may be immediate family members or relatives of considerable time owing to the large number of retrieved bodies and the fact that the search and exhumation exercise is still going on. Now, liken the situation of the rescued victims to the Stockholm Syndrome. In this situation, people develop positive feelings toward their captors or abusers over time. With them. This condition gets its name from a 1973 bank robbery. Captive bank employees became sympathetic toward the bank robbers. and even raised money for their defense. Our criminology, some bank employees showed toward the bank robbers. Movie lovers in addition to the kidnapper hostage situation, Stockholm syndrome used. Odunda, I know you didn't know that. That is my free contribution to education. Is that the offenses under investigation are largely linked to extreme religious ideologies in which it was also alleged and has been reported in the meeting in observance of their religious belief. Revealed that the victims had died of starvation. I am aware that I cannot and should not be cause for alarm. The circumstances of the matter indicate that the offenses under investigation, if they are linked to extreme religious ideologies and given the number of retrieved bodies and dress outfit, I would agree that releasing the respondents at this stage would jeopardize the together with the submissions by the state and the victims indicate that there is a high likelihood. In such circumstances, it would be unsafe to release the respondents before the potential witnesses at this stage. The forensic analysis to establish the identity of the deceased and their some of the deceased and missing persons may be their close relatives. In the interest of it is not clear where the 2nd to 17th respondents hail from. If they are from different parts of the country, as many they prove difficult for proper investigations to be conducted. Due to the large number, this is an exercise that would require the smooth and timely participation of the right to be free from intimidation, harassment, fear, tampering, bribery, corruption, of bail and release of the suspect. The state alleges that as that upon conducting postmortems, some of the deceased victims appear to have been subjected to violence so as to assist in the investigations. From the submissions by the state and counsel it was alleged that the first respondent is or was the leader of the extreme ideology. The state indicates that some of the rescued victims have narrated that there was employ force and violence. The 2nd to 17th respondents are believed to be part of that group. From the scene, the state alleges that there is need to conduct identification 13 respondents are involved in the offenses under investigation. The rescued victims are expected their current state of health. As alleged, it may not case would warrant the conduct of identification parades. The incidents under investigation appear 2nd to 18th respondents are released before such parades are conducted. There is no guarantee the state and victims are anything to go by. It would appear that the respondents may be in a position. Releasing the respondents before conducting the ID parades would expose the potential witnesses are close relatives of the respondents. The search and rescue efforts. I am inclined to agree that if the respondents are released, this respondent procured a lorry believed to have ferried adherents from Shakahola Forest to Kakuyuni Forest. On a balance of probabilities, the existence of compelling reasons to deny the respondent the grounds opposing the release of the respondents on bond. The evidentiary or choose not to say anything concerning the facts, the court is likely to find the suspected adherents from Shakahola Forest to Kakuyuni Forest. It was also alleged that it was further alleged that the relatives of some of the respondents were missing and others suspected to be among the state alleged that there is reason to believe that there was financial and material gain, that if released, the respondents are likely to waste or dispose of the properties or conceal records lacking in seriousness. I say so because it appears to be a shot in the dark. And if there was such evidence, the state has not demonstrated how the continued incarceration of the existence of property, it cannot be said that the respondents are likely to waste disposal and the victims that the Shakahola incident has stirred public anger, that it would be in the interest of in the case of Nicholas Kipsigei teach to ensure the security and safety of the applicants, a duty from which the state can be in the mouth of a state official charged with this duty to imply that Kenyans will only A of the Criminal Procedure Code, a suspect can be denied bail on the ground protection. In my view, the requirement that the court must be satisfied behoves the procedure must be real and not imagined. and security. Some judges contend that such cannot be a ground to be considered into their own hands. The authorities of Nicholas Kipsigei and Gibson Kiplangat relied upon by security. In the authority of Gibson, Kiplangat bet security is without legal or factual basis. For instance, the authority of David Ocheng the foregoing clearly illustrates that there are two different schools of precedent dictates that the decisions of the higher courts are binding on the lower court. In the case of Justice Jean Gachesha of the High Court held as follows, quote, the circumstances in which there are conflicting previous decisions of the court or the previous decision is inconsistent. As a general rule, though not exhaustive, the only cases in which decisions or some inconsistent statutory provision or some authority binding on the court found on that account to be demonstrably wrong. By the same court, I will be entitled to choose which decision to follow. There is a legal basis for denying a suspect bond or bail on account of his 123A of the Criminal Procedure Code and Section 33(5) of the courts need to be pragmatic in their approach to issues before them. Those suspected of having committed crimes or even convicted and are serving every citizen, save for the lucky few in high places, for those who are privileged. Eyes to the real situation on the ground and expect that nobody would break the law simply in the country. I am persuaded that the safety and security of the suspect is a The court is simply being realistic. It was submitted by the state and on behalf of the victims that if the respondent and emotions are high. Paragraph 33 of the affidavit in support of brought down a wall and damaged vegetation on what was believed to be the first respondent. It's not disputed by the first respondent. Mr. Kariuki, counsel for the respondents, appeared that it was just a building and not a church. The first respondent I am satisfied that the safety and security of the respondents generally may be at risk And in such circumstances, the Temboska Kipchumba, the court held that in an application of this nature, the state must sing in absolute good faith, and that the continued detention of the individual without a charge circumstances. 2. The state must demonstrate that the continued detention of the interest present in a potential criminal trial, that is, the rights of the arrested individual, of the administration of justice, and the interest of victims of crime. Where Articles 21 and 259 of the Constitution, the court must act to grant. Differently put, the state must demonstrate that there are compelling reasons to deny quadruple interest, and without reifying or essentializing was substantially in the form of lamentations and complaints regarding how the respondents submitted by Mr. Komoro, learned counsel for the respondents, that the period of 90 days sought by the, considering the gravity of the matter and the nature of the investigation and psychosocial support, I doubt that the delay is unwarranted. The application, together with the affidavit in support of the application, in support of the application details how and when the respondents were arrested. It further explains on the operations and rescue of victims. The affidavit in support of the application address search and rescue operations. I disagree with the respondent's assertion that but this is no ordinary incident. It is a catastrophe that seems to have a state. The respondents further submitted that the application was an abuse of the process of the seeking an extension before the Malindi court. They closed the matters. It was submitted by the file, but should have sought an extension of time. The affidavit the Malindi court was grossly insufficient. The state opted to close the matter at Malindi. The Shanzu court would raise eyebrows. I must admit that the state, through the depicted within the confines of the law. In the absence of any evidence of mischief, argued that since Shakahola was under curfew, there is no way that the respondents would interfere with the crime scene. I have already discussed here and above the issue of interference with the investigation. Land where bodies were exhumed belonged to the first respondent, and that no post-mortem forms were Next affidavit containing the allegations against the respondents. The first respondent did not deny control over the same. As rightly submitted by Mr. Abubakar, an affidavit did not do so. As already indicated, the Shakahola saga is now a matter of general died of various causes as stated in the affidavit. Facts respondents also raised issues that would otherwise be canvassed at the trial in the event that the main issue is whether there are compelling reasons to continue holding them in custody pending completion of and the complexity of the nature of the investigations involved. The magnitude missing. This is a matter that has caused national and international concern. It is in the public interest and the interest the liberty secured by the Constitution of Kenya to every person within its circumstances wholly freed from restraint. There are manifold reasons. On any other basis, organized society could not exist with safety to its members. Warrant the continued detention of the respondents. I have pondered over the issue of whether I agree with the state that releasing the respondents at this stage would undermine the respondents without charge is the least restrictive action it can take in balance the integrity of the administration of justice and the interests of the victims. Being aware of the respondent's right to be presumed innocent until the contrary is committed the offenses under investigation. In the application, the state has prayed for detention of the respondents for a period of 90 days. Code and Prevention of Terrorism Act respectively provide that where the court orders for extension at a later stage. The state rightly appreciated this provision is reasonable and justifiable in an open and democratic society with a limitation. I find that the integrity of the criminal process bond terms. Consequently, I find that the application is made as follows. A. The application by the state is allowed pursuant code and section 334C of the Prevention of Terrorism Act. B. days from the 3rd of May 2023. For the period aforesaid. D. The respondents, while in custody, During the time of detention, the respondent shall be granted reasonable access to their advocates and family or any other person whose assistance will be necessary. The respondent shall have the right to communicate whether by telephone or other means with any at which the respondents are held shall facilitate the examination, treatment, and healthcare whenever such need arises. Shall be required to submit a report indicating the general status of the court. Your WhatsApp numbers or email, just a minute. Email members of the Fourth Estate. This is a media. Yes. President, just arrived. Yes. Why don't you leave that? Don't try to appeal before me. Yes. Yes. Therefore, ruling alone or proceedings and ruling? Yes. We expedite the same. Yes, you are done. Yes. Yes. I didn't have to mention that you have a right to appeal. Yes, Mr. Kariuki. Yes.
especially from the well. Yes, it may. I wish to inform the court of the following. In custody, they sleep on the 7th. They feel in this rain season. And they have pains in their ribs. If they are to continue, even before investigations are over, the possibility of death. Of this trial delaying in the event if there has to be a trial because of their bad health.
So
And also verdicts.
you ask.
They have none, and the state has opted to give them. Your Honor, they feel they are not being punished because of. It's now even awful. We should tell them.
But the quality.
I'm saying the quality of the food is such that I want to explain what I mean by quality. That is the only meal that is there. A splash of a liquid that could be an extract from this soup. This I have seen it, and I'm submitting on what I have seen.
Yes.
It has worsened because they complain. We are saying that this is the right. We are not making any example. I'm instructed that there was some money that was recovered. From the 150,000 Kenya shillings was recovered. This money has not been returned, or its whereabouts we don't know. And have that record. If they money is sufficient to take care of them. And that is in good faith to say that. And help themselves. It's in good faith.
Yes.
May I also submit that in this further interrogation of education plans and positional right against self-incrimination by compelling them or forcing them to do anything that is unconstitutional. Talked about. Requires within the law. There be to also be denied our plans. When in the presence of the police officers, documents which are not read out to them, in court against them. Included in conduct legislation was
Mr. Jami.
Express our satisfaction with the decision that you've just rendered. In anticipation of the defense from the High Court.
are we
I hope it comes back.
fully loaded?
A decision we should share with students of the procedure.
To share. Anyway, proceed.
This application that has been made before you, I don't know whether it's an application or concerning the accommodation being provided to we propose that so that we are able to seek instructions and respond, if it is an application, it should be made formally. Your Honor, we pray that